Thank you, everyone. We welcome you to the first National Moot Court competition of Nyayavani Foundation. Before we begin, let me briefly share about Nyayavani Foundation. Nyayavani is a non-profit organization dedicated to providing access to justice through legal aid, awareness, and capacity building program. Along with community outreach, we focus on nurturing the next generation of legal professionals by creating opportunities for experiential learning and mentorship through initiative like this competition. We at Nyayavani strive to create a space where learning meets awareness, where young minds are encouraged to think critically and understand law not just as a profession, but as a medium for change and empowerment. Today, we are honored to have with us Honorable Dr. Pragnya Patil and Honorable Mr. Parth Sharma as our adjudicator for this round. On behalf of Nyayavani Foundation, I extend our sincerest gratitude to both of you for your presence. Honorable Dr. Pragnya Patil ma'am is an accomplished legal academician and mooting mentor, a gold medalist from University College of Law, Dharwad. She has won awards such as Best Lady Advocate at the SC Javali Moot and Best Memorial at the CMR Moot with participation in 11 national competitions. She holds an LLM in Business and Trade Laws and a PhD on e-commerce laws from Karnataka University. With over a decade of teaching experience, she has served at KLE College, Law College, Ramaiah College of Law, and as a principal at Oxford College of Law. She is currently the principal of KH Patil College of Law, Bangalore, known for her expertise, leadership, and passion for mooting and legal research. Dr. Patil continues to inspire young law students. It's an absolute privilege to have you with us today, ma'am.
Thank you, Aradhya.
Thank you, ma'am. Honorable Mr. Parth Sharma, sir, is an assistant professor of law at School of Law, Mahindra University, Hyderabad, with over 7 years of teaching experience. Currently pursuing a PhD in law, he holds an MPhil in law, an LLM, and a BLLB honors degree. Mr. Parth has also been a LAMP Fellow at PRS Legislative Research, reflecting his deep involvement in parliamentary procedures and policy analysis. His primary areas of interest include constitutional law, administrative law, media law, consumer law, and parliamentary procedure. Mr. Parth combines academic rigor with practical insights, making him a valuable contributor to legal knowledge and research. It's an absolute privilege to have you with us today, sir.
Thank you, Radhya.
We appreciate both of your presence and expertise, which will make this event a huge success. We thank you for being a part of it and for making the event a huge success. With the permission of judges, we will now commence with the rounds.
Yes, we may proceed.
If it may please the Honorable Court, this is counsel appearing on behalf of the petitioner in the matter of association of journalists, activists, and lawyers versus the Union of Aryabharta and another. For the betterment of proceedings, the council seeks permission to collectively address the bench as your lordships and individually as your ladyship and your lordship. Much obliged, your ladyship. Your Lordship, the Council has filed the present public interest litigation under Article 32 of the Constitution, seeking for the enforcement of fundamental rights. The public interest litigation has also seeked a direct probe into the alleged state-sponsored trolling that the Union of Aryabharta is a part of. With the permission of the Lordships, the Council will provide a brief of the facts.
Yes.
Much obliged. Your Lordships, within the state of Aryabharta, the JSP is the ruling political party. Ms. Kavya Menon had published a book titled Digital Warriors Inside the Secret Army of the JSP, in which she had made three main allegations. The first one is that there is a state-sponsored online social media trolling machinery. The second one is that this machinery targets women leaders, women journalists, and opposition leaders. The third allegation that Ms. Kavya Menon has made is that the ruling party uses the volunteers to control narratives online. After the publication of the book, Ms. Kavya Menon had received various threats online, and even a few verified party functionaries had called her anti-national and leaked her personal address. Subsequently, her home was vandalized. The present public interest litigation has been filed within the Supreme Court of Aryabharta, seeking for enforcement of fundamental rights of all of the journalists and opposition leaders in the country. If your lordships permit, the council will proceed with the statement of issues. Much obliged. Your lordship speaking council will be dealing with issues 1 and 2, and my co-counsel will be dealing with issues 3, 4, and 5. Your lordships, before we begin with the arguments, the council would like to humbly contend that this is not a private matter between Ms. Kavya Menon and the JSP. This is a public interest litigation that has been filed by an association representing the greater interest of the public at large, Your Ladyship. The council will now move on to the arguments under issue 1. Your Lordships, issue 1 is whether the coordinated online trolling violates articles 14, 19, and 21 of the Constitution of Aryabhatta. Before the council dives,
Council, how is it an issue at large? Because you just highlighted it. You said that it is PIL. Can you please justify why did you choose to file a PIL?
Your Ladyship, what has happened to Kavya Menon is an isolated incident, Ladyship. The public interest litigation was filed to provide better protection for journalists in general in the country of Aryabhatta, Your Ladyship. That is why the public interest litigation has been filed, seeking for better protection and better laws to be implemented effectively in the country of Aryabhatta. Your Ladyship,
So it has been filed by various associations, right? How are they related to this case?
Your Ladyship, the association is a single association that includes journalists, activists, and lawyers, and they are the ones who have filed the public interest litigation.
Okay, proceed.
Okay, much obliged. Your Ladyship, before the council delves into the first issue, the council would like to talk about the maintainability of the public interest litigation. Your Ladyship, the council humbly contends that the present public interest litigation is maintainable. In the case of Society for Enlightenment versus Union of India, the court had clearly given there was already existing statutory provisions for child marriage, but the petition had still challenged, stating that the laws were not implemented effectively. In that case, the court had allowed a petition and had let the petitioner seek for better guidelines with respect to the subject of child marriage. In the present case, there are existing statutory remedies that deal with the problem of online trolling. However, the implementation and the effectiveness of such laws is what's being disputed in the present situation. Therefore, the council is appearing on behalf of a public interest litigation on this ground. Moreover, your lordships, the council would like to divert your attention to the fact that this is not a public interest litigation that is being filed based off of allegations. The public interest litigation is being filed based off of verified facts, your lordship. An argument alleging that the public interest litigation relies on allegations and no fact bears no merit in the present case. There is an existence of a hostile group that is constantly trolling people that speak up against the government. The council will provide two circumstances which proves this fact, your lordships. The first one being that after the publication of the book by Ms. Kavya Menon, she had immediately received backlash from a group which was criticizing her and threatening her for publishing a book against the government. Secondly, if the council may direct your attention to paragraph 5 of the facts, it is mentioned that the Union of Aryabhatta, Union of Aryabhatta clearly states that these abuses were carried out by private individuals. The Union of Aryabhatta has never denied that online abuse exists. Rather, it has constantly strived to maintain that it is not liable. Yes, Your Ladyship.
Can you please open your fact sheet? The one
Yes,
that you
Your
have submitted.
Yes,
Do
Your
you have
Ladyship.
para number 5 there?
Yes, Your Ladyship. The council has para number 5. With the permission of the Ladyship, the council will read it out for the betterment of proceedings.
Yes. Now the fact sheet, the statement of facts that you have provided in your memorial.
Your Ladyship, the council is talking about the Moot proposition.
No, but have you included this part in your statement of facts?
Your Ladyship, the council has provided a concise presentation of the statement of
But
facts.
have you included this part? Even if it is concise, is it there as part of your statement of facts?
Your Ladyship, the state's position on this issue is not included in the statement of facts provided by the council.
Then don't state it.
Your Ladyship, it is essential to understand.
How can you just skip a part of, as you are quoting it, it is essential, right? And how can you just
Certainly,
skip
Your
it
Lordship.
from your statement of facts? You do not have the liberty to cut the fact sheet. You may concise this, but you cannot completely, erase the fact sheet, part of the fact sheet.
Your Ladyship, as the state's position is being disputed in the present case, the council decided to elaborate on that particular section of the facts
But
in
you
the
have,
argument.
my question to you, counsel, is you have not mentioned that in your statement of facts.
Certainly not, Your Ladyship. But if Your Ladyship would like to direct your attention towards the moot proposition, it is mentioned in paragraph 5 that the state has not denied that online abuse exists. Rather, it clearly exempts itself from liability, stating that it was carried out by private individuals. Leadership, the council submits that based off of these two circumstances, mainly the backlash received by Ms. Menon after the publication of the book and the state not denying that there exists an online abuse, the council humbly submits that the public interest litigation is submitted based off of facts and not baseless allegations.
Counsel, how the state can deny that the online abuse does not exist? Because there are all sort of offenses and crime they are existing. Just because we have a government or state, that does not give a guarantee that it won't happen. So how that would be considered as a public interest litigation? Because we already are having existing laws to deal with those situations.
Your Lordship, to answer your question, the council would like to state that the existing remedies, they only act once an offense has been committed. The council is stating that to provide a legal remedy after the commission of an offense is the role of the judiciary. The role of the legislature is to enact such statutory provisions that are sufficient to prevent as well as punish the offense that is being disputed in the present case. And to answer your question, Your Lordship, this is not a general case of online abuse that the state is denying. The state has clearly mentioned that social media abuse is carried out by individual citizens exercising their free speech right. The state has filed a response
None of which
only,
you have chosen to add in your memorial.
Your Ladyship, as the council humbly contends that the council wished to elaborate on that in the upcoming arguments. That is why it was not mentioned in our fact sheet, Your Ladyship.
And counsel, you have filed this PIL against?
Your Lordship, the PIL is filed against the Union of Aryavarta as well as the intermediary, Shirap Incorporation.
Okay.
Your Lordship, the council would like to submit that there is a clear violation of Article 14. The targeted abuse towards the women journalists and opposition leaders clearly demonstrates that the online abuse carried out has an irrational nexus and therefore violates Article 14 of the Constitution. The state's failure to protect a class of people against such online social abuse clearly demonstrates that the state is also violating Article 14 of the citizens of the country. In the case of Kishore Keswami versus the Inspector of Police, the court had clearly held that when a person commits an act against a selective group of women, it not only demonstrates his intention towards the women, but it demonstrates that the freedom of equality, which is enshrined to all women in the Constitution, is being at dispute in the present case. Moreover, if your lordships would like to turn to the case of Amish Devkan versus Union of India, the court had clearly held that hate speech cannot conceivably contribute to a democracy in any positive way, and it repudiates the right to equality. Therefore, the council humbly contends that when hate speech exists in a state like Aryavarta, and when the state has not taken any measures to prevent hate speech, it violates the right to equality, which is guaranteed to the journalists and opposition leaders.
Counsel, you are citing Kishore Keswami case, right?
Yes, Your Lordship.
This has been decided by which court?
Your Lordship, the Honorable Madras High Court has dealt with this case.
Whether the present case is still sub judice before the Supreme Court, Honorable Supreme Court? Whether the party who has lost this case, whether they have filed an appeal to Supreme Court, whether there is some development in this regard?
Your Lordship, as per the knowledge of the council, the case was decided in the Madras High Court, and the council has council has relied upon the judgment of the Madras High Court. Your Lordship.
Okay.
Your Lordships, the next submission is that the trolling and online violence creates a chilling effect under Article 19, Clause 1, Subclause A. Your Lordships, the intimidation faced by women journalists based off of such online trolling clearly violates their right to freedom of speech and expression. It prevents them from publishing the truth because the journalists are scared of what would happen to them. That is the state of the country of Aryavarta, the state of affairs of the country of Aryavarta in the present scenario, Your Lordships. It is humbly contended that in the case of Ghazi and others versus Serbia, the European Court of Human Rights had observed that coordinated trolling campaigns against journalists gave them a reason to fear for their safety. It prevented them from openly criticizing the authorities. Your Lordship, it is submitted that the right to criticize and the right to political and the right to freedom of press is a constitutionally protected right, Your Lordships, and the state should take measures to protect such a right, Your Lordship. The council would like to direct the bench's attention to S. Rangarajan versus P. Jagjeevan Ram, which is mentioned under S. Rangarajan versus P. Jagjeevan Ram. The Honorable Supreme Court had held that it is the duty of the state to protect the freedom of expression, since it is a liberty guaranteed against the state. In the present case, the right to freedom of speech is guaranteed against the Union of Aryavarta, and it is the duty of the state to protect the right to freedom of speech and expression.
Counsel, can you explain facts of S. Rangarajan case in 2 lines?
Yes, Your Lordship, certainly.
Without referring to your notes?
Yes, Your Lordship. In the case of S. Rangarajan versus P. Jagjeevan Ram, there was a criticization of caste inequality and public objections of threats of violence in a film, Your Lordship. Therefore, the government had to revoke the film's certificate because of the dispute that was happening.
Okay.
Your Lordships, the second fold argument under the violation of Article 19, Clause 1, Subclause A is that the hate speech has an incitement to violence. The council will now demonstrate in a threefold manner how the hate speech has violated, how the hate speech has incited violence in the present case.
Counsel, before that, could you please just in one line tell me what was your main argument here in first issue? That the government should have, correct me if I'm wrong, you have just, your argument is that the government should have enacted a legislation preventing such activities, and hence it is violative of Article 14. Am I correct?
No, Your Ladyship, the council would like to humbly submit that the state
Yes.
that the state has not protected the right to equality of the journalists and opposition leaders by allowing the ruling political party to carry out such online social media abuse that is specifically targeting women journalists.
Is that argument there in your memorial?
Your Ladyship, it is mentioned in our memorial that Article 14 is being violated on page number 14, Your Ladyship.
Okay, page number 14. Okay.
If Your Ladyship would like to take a look at paragraph number 7 of page
I'm
number.
looking at it. Yeah, somebody sent the coordinated online harassment directed at women journalists and political critics amounts to violation of Article 14. No, but it doesn't mention that the state should have enacted a legislation, failure of which has amounted to violation of Article 14.
Your Ladyship, the council is not contending that the state has not
Your
enacted
argument.
legislation.
Okay.
The council humbly contends that whatever legislation the state has enacted, it is ineffective in the present manner. The council is not contending that there is no legislation at all with respect to online trolling.
Okay.
Your Ladyship, the next limb of the argument that Article 19, Clause 1, Subclause A is being violated in the present case, the council would like to rely on the case of Shreya Singhal versus Union of India.
Coordinated online harassment directed at women journalists and political critics amounts to violation of Article 14. Please
Yes,
explain this.
Your Ladyship, in the present case, public interest litigation has been filed because the online social media abuse is being carried out against a selective group of women journalists and opposition leaders. Therefore, it violates the right to equality under Article 14, Your Ladyship. The council
So
will
against
also
whom can you challenge the violation of Article 14?
Your Ladyship, Article 14 violations can only lie against the state. The Council will elaborate and demonstrate how the JSP is a part of the state in the upcoming arguments, Your Ladyship.
Okay. Should have been
Much obliged.
convenient if you could explain it here, but it's fine.
I'll explain it, Your
You
Ladyship.
can explain. Yes.
If
Brief.
it permits, I can explain it briefly right now.
Yes. Yes, briefly.
Your Ladyship, the ruling party is an instrumentality of the state. This is the main contention that the council would like to make. It was held in the case of Ajay Hasya versus Khalid Mujib, Sehrawadi and others that when an entity performs functions closely intertwined with governmental activities, then it can be treated as a state for the purpose of Article 12. Moreover, Your Ladyship, in the case of Ms. Anumeha versus Chief Commissioner of Income Tax and others, the court had clearly held that political parties come to wield or directly or indirectly influence exercise of government power. The council would also like to submit that courts have interpreted the ruling party as part of the state because they are substantially funded by the state, Your Ladyship. Hence, considering all of these factors, in brief, the council would like to submit that the ruling party is part of the state and the actions of the ruling party, namely carrying out coordinated online polling, would make the state liable for the actions.
Okay, we'll discuss about this when you are discussing in elaborate.
So, Council,
You
what
can
kind of
continue with-
financial or administrative control is there of the state or the government over the political party?
Your Lordship, to answer your question, the state sponsors the political parties' funds, Your Lordship, their housing, their transport, everything is funded by the state, Your Lordship. The ruling political party also forms the government. Whether the ruling political party is in full control of the state, that the council is not contending. The council is simply contending that the ruling party is an extension of the state under the ambit of other authorities under Article 12 of the Constitution.
Cite any case where political party was held to be a state under Article 12 by Honorable
Certainly,
Supreme
Your
Court.
Certainly. Your Lordships, it is held in the case of Association for Democratic Reforms versus Union of India that political parties are intrinsic to this form of government because of the very process of government formation. In the same case, it was held that political parties are central to the governance structure, Your Lordship.
Particularly, political parties are state under Article 12. Because you have cited Ajay Hasya case, in that also they have said the list is not exhaustive. It is merely illustrative, not conclusive, right? So any specific
Certainly.
case where the court has directly observed that political party will fall within the category of state under Article 12. Do we have a case?
Your Lordship, the Council did submit the case of Association for Democratic Reforms versus Union of India, where it was held that the political parties are central to the governance structure. Therefore, it makes them fall under the ambit of Article 12 of the Constitution. If your Lordships would direct yourself to page number 20, paragraph 37.
Just answer yes or no. In any of the case, directly the court has said political party can fall within the category of state under Article 12? Or you are just drawing an inference with the obiter of the case and the guidelines in the different case?
Your Lordships, courts have interpreted political parties to come under the ambit of Article 12 of the Constitution. It is merely an interpretation of Article 12 the courts have performed. Your Ladyship, the final submission in the first issue, the Council would like to demonstrate how the fundamental right is violated by incitement to violence. Your Lordship, in the case of Shreya Singhal versus Union of India, there was a crucial distinction between discussion, advocacy, and incitement. In the present case, in the same case, the court had held that when hate speech reaches the level of incitement, which means that it has a direct tendency to cause public disorder, then it can be restricted under the ambit of public order, which is constitutionally guaranteed under Article 19 clause 2. Furthermore, Your Lordships, the Council would like to submit that in the case of Simon Bikindi versus the prosecutor, it was held that incitement can be inferred even if the hate speech is indirect. It was understood by the intended audience and violence was ensured as a result. Your Lordships, in the present case, taking Ms. Kavya Menon's case as an example, Your Lordships, a hostile environment was created when the state's political functionaries, namely the verified political functionaries of the JSP, had called her anti-national and leaked her personal address on a social media forum. Your Lordship, even if the intention was not to vandalize her house, the targeted audience had received the private address of Ms. Kavya Menon, and subsequently, there was a damage that was caused to Ms. Kavya Menon. In that instance, hate speech should have been restricted under Article 19, Clause 2. Hate speech should have been restricted under Article 19, Clause 2, but the state did not take any action on that, Your Lordships. That is the final limb of the argument that the Council would like to submit within the first issue. If Your Lordships have no further queries, the Council will proceed with the second issue. Your Lordship, the Council
time is
seeks an
over,
extension.
so briefly state the crux of issue 2, whatever arguments you want to make, right?
Yes, Your Lordship. Council will humbly state that the social media posts were made by the recognized members of the JSP. Your Lordships, if Council would like to divert your attention to paragraph 7 of the Moot proposition, Council will read out the paragraph. After the release of the book, Ms. Menon received thousands of threats online. A few verified party functionaries openly call her an anti-national and demand her arrest. One of the posts even shared her home address. Your Lordships, this statement is clearly made to indicate that it was the party functionaries who committed the act of leaking her personal address on the social media forum, and subsequently her house was vandalized. Moreover, alleging that the unofficial structure of the JSP means that the state cannot be liable for the JSP and the JSP cannot be liable for the volunteers is a baseless allegation. The Council clearly submits that as per the guidelines prescribed by the Election Commission of India and under Article 324 of the Constitution of Aryavarta and Section 29A of the Representation of Peoples Act, the guidelines mandate a proper structure for the political party. There is a clear hierarchy that is established in a political party, and JSP being the ruling party, 100% it has registered with the taking the above mentioned precautions and establishing a clear hierarchy within their party. Therefore, the claim that it was the actions of the volunteers and not the action of the JSP does not lie in the present case, Your Lordships. The final limb of the argument that the Council would like to make is that assuming but not accepting that the JSP is not a part of the state nevertheless has a positive obligation to protect the fundamental rights of each and every citizen. Your Lordship, it is submitted that in the case of Kaushal Kishore versus State of Uttar Pradesh, the court had clearly held that the state has a positive obligation to protect the rights of citizens under Article 21, whether the violation is by its own functionaries or by private actors. Your Lordship, assuming but not accepting that the JSP is a private actor in the present case, the state still has an obligation to protect the fundamental rights of one party against the actions of another party, Your Lordship. The Council would like to conclude issue number 2 with the statement that the JSP is a part of the state and the actions of the JSP are attributed to the liability of the state. And therefore, the Council concludes that the state is liable for its failure to perform its positive obligation to protect and enforce fundamental rights.
Council, one quick question. So,
Yes.
the problem why you have approached this honorable court, it is lack of intent of the state or government, or there are laws which are inadequate. You have a problem in terms of enforcement mechanism of the existing laws, or you are saying the existing laws are not adequate enough to deal with that situation?
Your Lordship, the Council is agreeing with both of the statements. There is an inadequacy of the laws, Your Lordship, and they're also inefficient in implementation of the laws. The current laws that are being implemented are not effective enough to curb the problem of online trolling. That is a statement that the Council wishes to make.
Okay, so one question ki you are saying that public interest litigation, whether the court can direct legislature to enact a particular law?
Your Lordships, the court cannot directly issue directions to the legislature to provide a specific law. However, until the legislature makes an attempt to curb this issue, this honorable court has the power to issue interim guidelines, Your Lordship.
Okay.
Council would like to cite a case, Vishaka versus.
That's all sufficient. Thank you.
Much obliged, Your Lordships. Co-counsel will be taking over now.
Your Lordship, am I audible?
Yes, you're audible.
If it may pleases the court, the council seeks permission to begin with the third issue.
Yes.
The third issue is whether the
Proceed.
restriction on political use of social media would amount to reasonable restriction under Article 19, Clause 2. It is humbly contended before the Honorable Court that the restriction on political usage of social media would definitely fall within the ambit of reasonable restriction under Article 19, Clause 2. The Council would like to deal this particular issue on twofold. The first limb of the argument focuses on that political use of social media is subject to reasonable restriction and falls within the ambit of public order under Article 19, Clause 2. And next set of argument focus on the proposed restriction does not violate the freedom of speech and expression are necessary to ensure the democratic forum stays intact. Your Lordship, as the first set of arguments being advanced, the Council like to humbly submit before the Honorable Court that if a restriction were to put on this particular aspect of freedom of speech and expression, that under the grounds of Article 19, Clause 2, under the enumerated categories of public order, then I have to prove that the same particular aspect of freedom of speech and expression left unrestricted would cause public disorder. To explain that particular aspect of restriction, the council like to make emphasis on the case of Dr. Ram Manohar Loya versus State of Bihar judgment, because Honorable Supreme Court has very clearly established how a particular act can be dealt in the manner of how does it determine whether it violates law and order or public order at large. Here, the court has given an illustration as to understand how this particular act or particular person's act, not based on its nature, but rather based on the consequence that has on the society, will determine its nature, whether it violates law and order or public order. The super emphasis basically that court illustrates that a scenario of women facing advances in the public forum would definitely mean that there's a minor breach of law and order. But the same thing consistently or perpetrated by the men against women on harassing women or making advances against women, that will definitely establish a deterrence among the women to not to participate in those public forums where they could possibly face advances, and that would violate the public tempo, which basically the public tranquility at large would be violated, and that would qualify as a violation of public order, Your Lordship. In the instant case, if you look at it, the attacks on social media has been very carefully crafted to target a specific section of society, harassing them on the basis of communal and sexual explicit content. In addition to that, the council like to submit before the Honorable Court that the social media is a modern amphitheater where all sections of the society must be accommodated and environment must be free enough to encourage all forms of participation from all sections of the society. But in addition to that, the council like to cement the underlying nexus between a particular act and a public order by way of elucidating the theory of broken window theory, Your Lordship. It posits that a visible sign of minor disorder such as broken window or vandalism creates an atmosphere that encourages more serious offense, all because of a simple signal from the society that it lacks social control. Here, unrestricted freedom of speech and expression has went on to political parties using their instrumentality to harass the critics, amplify hate speech, and even the share the residential address of the Kavya Menon, which went to the extreme consequences of destroying or vandalizing her entire property. That shows that the unrestricted freedom of speech and expression has violated the public order, and that mandates a restriction on that particular aspect. Even the court has acknowledged this particular lack of restriction in different times. Even in the case of Ajit Mohan, the Legislative Assembly of NCT Delhi, court has very clearly held that these platforms has become a power center themselves. Having the ability to influence a vast section of society, this unprecedented degree of influences necessitates safeguard in consonance with the democratic values, Your Lordship. In
Which
addition to
paragraph?
that, the council,
Which
Your
page
Lordship,
and
the council
paragraph?
like to draw the bench's attention towards para number 62, where the council has submitted the Honorable Supreme Court's judgment of Ajit Mohan versus the Legislative Assembly. And
Okay.
possibly in the third line, it has very clearly held that these platforms has become a power center themselves, having the ability to influence a vast section of the opinion. In addition, they went on down to say that this unprecedented degree of influence necessitates a safeguard and caution in consonance with the democratic values, Your Ladyship.
Okay.
Your Ladyship has answered on that particular question. The council like to move on to the next set of arguments. Your Ladyship, that it has humbly submitted before the Honorable Court the reasonable restriction on political use of social media will not violate the freedom of speech and expression and is necessary to preserve the democratic forum. Your Ladyship, it can be presumed that a particular act of restriction on freedom of speech and expression, especially on the political usage of social media, might cause a chilling effect. But the same contention made by the respondent in their memorial does not hold weightage, because it is easily possible for a particular person to differentiate between law and order and public order. As we have already discussed from the case of Ram Manohar Lai of the state of Bihar, it is very clearly evident that the instant factual circumstances very clearly elucidate that particular point, that there is a violation of public order, not merely law and
Answer a
order in
little,
this junction.
pace it a little slower, because ultimate objective of your argument is we need to be convinced by what you're saying, right?
Certainly,
Right?
sure. Definitely, the council will reduce the pace. Your Ladyship, the council like to further substantiate the further arguments on the relying on the case of X Corporation versus Union of India, because in this particular judgment, the court has very clearly held that unregulated speech under the guise of liberty becomes a license to lawlessness. Your Ladyship, the council is drawing the opinion from section para 70 of the memorial, where the X Corporation is very clearly cited. Certainly, Your Ladyship. Unregulated speech under the guise of liberty becomes a license to lawlessness. On contrast, the regulated freedom of speech and expression protects and preserves both liberty and public order, Your Ladyship. And at the same time, on the both these are the pillars under which the democracy have thrived. And regulation on freedom of speech and expression is not something new or unique, Your Ladyship. At a different point in time, even in our jurisdiction, the court, Your Ladyship.
See,
Ladyship,
I understand that social media, as Justice Nagprasanna has rightly held, is a modern amphitheater of ideas. So it is an amphitheater of ideas, and everybody has a right to express their ideas,
Certainly.
right? So how do you propose to restrict it? What do you think is a solution? How do you want the laws to be proposed, or how do you want the laws to be, if you can make a proposal?
Certainly, Your Ladyship. In this particular juncture, the council is happy to elucidate a guidelines or an additional aid to the honorable court, through by way of which the council like to mention that the restriction, as we have seen that the social media is a modern amphitheater and everybody is allowed to express their opinion, but at the same time, their opinion should be in cognizance with the existing laws of the nation. In addition to that, Article 19 Clause 2 and Article 19 Clause 1A also not protects all forms of speech where it transgresses into other person's fundamental right and creates a environment that does not allow other person to participate in that particular amphitheater.
Council, it depends. Like what your, the book which was written, it was not taken well by someone else. Similarly, the comments made by someone was not taken well by the author, right? So it
Your
depends.
Ladyship,
How do you
again,
want to restrict it? Where do you put a bar? Like you
Your
can
Ladyship,
talk
the
only so
constructive
much.
criticism
This
on
is the
any
kind of
particular
message you can post, and this is the kind of message you're not allowed to post. So make a suggestion.
Your Ladyship, when on a particular content or anything communication that reaches a threshold where it transgresses into another person's fundamental right to even express an opinion, even in the case of Praveshi Balai Sangatan versus Union of India, where the court has went on to say that if a matter of hate speech that goes on or transgress into another person's fundamental right to not even make an expressed opinion, and even in those instances, it creates an environment, Your Ladyship. Let's say a person's perception might be different from one another, but at the same time, a person cannot make a comment against another person discriminative in nature, such as hate speech or any form of trolling that does not even allows. If you look at the instant facts, it is very clear that the factual metrics elucidate the sexual. There has been a use of sexual explicit content, and there has been harassment solely based on the communal background a person belongs to. That kind of freedom of speech and expression does not have protection under the Constitution of Aryabhatta.
But it is all over social media, and how do you wish to, implement this law? Because it is all over social media. Every other person is writing these kind of comments on every other photo that is posted online. If it is open for public, they would like to comment on in a certain way. So how do you wish to implement this law of yours, like the one that you're suggesting?
Your Ladyship, at this point in time, as we are essentially dealing with social media, we will be definitely, yes, we'll be dealing with intermediaries at large. And intermediaries are those platforms hosting all of these contents. If the intermediary is directed with an additional set of laws that explicitly says that these kind of contents cannot be further shared or hosted in that particular platform, the intermediary can effectively remove those content from their platform, and that has been a settled principle of law through Information Act Section 79 of the Information Act 2000.
Also, they do have an internal mechanism. Even the reports can be reported, and then they have an internal inquiry. Then they can take down that. Can you just answer in brief in 3 points? What is the loophole in the present BNS and IT Act that it is not able to deal with the present situation?
Certainly, Your Lordship. In this particular instance, the first pointed that the existing BNS, neither the IT Act deals with the ambit of dealing with hate speech. And next, it does not goes to an area where a particular individual person is being harassed by way of a group of people, because it was already acknowledged by the Honorable Court in the case of Twitter Incorporation versus Union of India, where there is a mass level of psychological and intellectual manipulation that is perpetrated in the social media. And that is why we want a restriction on the particular instance where there has been a specific set of audience being targeted by way of set of group, a special interest group, and those groups menaces that have been exercised in the social media has also been acknowledged by the court in the case of Twitter Incorporation with the Union of India, Your Lordship. These are the restrictions on which the council would like to have restriction, especially on the political usage of social media. If your Lordship is satisfied with the third issue, the council seeks permission to move on with the fourth issue arguments.
Yes, you may
Your
proceed.
Lordship, the fourth issue is whether the chip incorporation can be held liable for failing to prevent abuse in the light of Section 79 of the Information Technology Act. It is humbly contended before the Honorable Court that the chip incorporation can be held liable failing to prevent the abuse in the light of Section 79 of the Information Technology Act 2000. The Council like to deal this particular issue on twofold. The first limb of the argument focus on the intermediaries having a more proactive role, and next set of argument on the failure to observe the due diligence on behalf of the intermediary would result in forfeiture of their safe harbor protection guaranteed under Section 79. As we are essentially talking about safe harbor protection, the council like to draw the attention of the Honorable Court to the Section 79, subsection 2, clause A, B, C, put forth certain conditions that is supposed by the intermediaries to be observed to continue having safe harbor protection. On failing to observe the same would result in compromise of the safe harbor protection guaranteed to them. In the instant case, the council humbly contend before the Honorable Court that in the chip incorporation through the factual metric are very clearly negated any possibility of having responsibility to even remove the content. In addition to that, it is not that they don't have the knowledge of the content that is posted on the platform. They also have admitted that the existing abuse taking place in social media is a misuse of freedom of speech and expression. So that indicates, the factual metrics very clearly indicates that they are having a knowledge of existing abuse taking place in social media, but they're clearly having a hands-off approach. And the same has been rejected by the court various point in time. The council like to draw the attention of the court to IT rules intermediary guidelines digital media ethics code 2021, hereinafter referred as IT rules 2021. Your Lordship, here the rule 3 clause subrule 1 clause B enumerates 11 categories of content that are not supposed to be hosted by the platform, but in the failure to not supposed to be hosted by the platform by taking reasonable effort, but failure to observe those due diligence would result in forfeiture of their safe harbor protection. And same was held in the case of MS Humble Mobile Solution Private Limited, the state of Karnataka, as recent as 2025 judgment, Your Lordship. In addition to that, court has opined that the intermediaries are liable to lose their safe harbor status failure to meet their due diligence. Your Lordship, there is a difference between intermediate and significant social media intermediary. The Information Technology Act categorically differentiate between the both. The intermediaries are normal intermediaries, whereas the significant social media intermediary, as defined under Section 2, clause subsection 1, clause B, very clearly states that if an intermediary meets the threshold of 5 million users, then definitely they will qualify as a significant social media intermediary.
Counsel, as already told by my learned judge, ultimately your aim is to convince the judge, right? So you need to just keep your pace down so that the judge can understand. At the same time, you need to manage that 5 minutes are left and you need to complete the issue. So don't just completely read out
Certainly, Your
the
Lordship.
crux of the issue, your core arguments, right?
Certain. Your Lordship, the crux of the argument boils down to these particular contention. First is that first of all, the chip incorporation being equated to Twitter qualifies as a significant social media intermediary. And Aradhya Bachchan versus Bollywood Times is one particular judgment where court clearly did not accept the defense claimed by the intermediary at this point in time through the factual metrics. They have claimed that they are having a hands-off approach and they have no control over the content posted on its platform. And they've also acknowledged that they have the knowledge of the abuse taking place in their platform. The court rejected the defense claim by the respondent that intermediary does not have control over the content or video which is posted on the platform. And at the same time, as being a significant social media intermediary, they are, as per the Rule 4, Sub-Rule 4, even also ask them to have more further stringent mechanism to even to identify those content posted on its platform, Your Lordship. Failing to observe all of these content, all of these due diligence that is expected out of the intermediary to be observed. At the same time, violation of Section 79 strips them of any of the safe harbor protection that they have been enjoying so far, and that would mean that any content posted on the platform would essentially qualify as a liability upon the intermediary to be taken upon, Your Lordship. That's the contention for the fourth issue. Your Lordship is satisfied with the fourth issue's argument advance. The counsel like to briefly explain the fifth issue and summarize the arguments also, Your Lordship. Your
Yes,
Lordship,
you
the
may.
fifth issue, whether investigative journalism exposing state-sponsored trolling protected under freedom of press or whether it constituted defamation against the government. Your Lordship, it is humbly contended before the Honorable Court that this particular issue does not dial down into on a minor factual metrics. Rather, it has been framed in a manner to address the question of law, whether investigative journalism exposing the state-sponsored trolling will be protected under freedom of speech and expression. And time and again has court very clearly established that the freedom of speech and expression enjoyed by the investigative journalism falls within the ambit of freedom of press. And the court on its own motion versus state has very clearly enumerated that the media has full play in the matter of legitimate investigative journalism. This in accordance with our constitutional principle of freedom of speech and expression and in consonance with the right and duty of the media to raise the issue of public concerns and interest, Your Lordship. And at the same time, it is humbly submitted before the Honorable Court that at the instant point in time, whatever the comment or the allegation made by the investigative journalism at any point in time, by whatever the findings that comes out, it does come within the ambit of Article 19, Clause 1A as a freedom of speech and expression. And there has been no doubt on that particular instance, Your Lordship. Your Lordship is satisfied with the fifth issue. The counsel would like to move on with the prayer.
Yes. Proceed.
Your Lordship, the prayer. Yes, Your Lordship. Prayer. Wherefore, in the light of the issues raised, argument advanced and authority cited, it is humbly requested that the Honorable Court may please to allow the petition and declare a coordinated online trolling campaigns by the supporter of the ruling party violates Article 14, 19, and 21 of the Constitution, declare that the restriction on political use of social media would amount to reasonable restriction under Article 19, Clause 2, and constitute an independent inquiry or a special investigative team to probe into the existence of operation of state nexus of coordinated online trolling machinery and hold the respondent 1 liable for online abuse carried out by the supporters but coordinated through unofficial party structure and hold the defendant 2 liable for failing to prevent abuse, mandating proactive moderation, and declare that the investigative journalism exposing state-sponsored trolling is protected under freedom of press. Grant a permanent injunction of restraining any future coordinated online trolling or harassment of the petitioner and similarly situated individuals, Your Lordship. And on the other, on any other order as it deems fit in the interest of
Counsel, I
equity,
have
justice, and good conscience.
Counsel, you just prayed that we should hold that defendant 2 is liable for failing to prevent abuse and mandating proactive moderation, proactive moderation.
Yes, Your Lordship.
I had asked you a question that how else would you want them to prevent? Because as you also agreed that there is a law in place, right? You said that there is a law in place, and yet you say that they
Certainly.
failed completely in providing the remedy or trying to prevent. So there is something amiss. On one hand, you said there is a
Your
law,
Ladyship,
and then you say that.
Your Ladyship, if the counsel like to clarify that issue or question that you posted by the Honorable Bench, the question is whether there is an existing law and the chip incorporation has violated. And further, you're asking
Yes.
for a further more restriction. Exactly, Your Ladyship.
Yes.
Your Ladyship, the existing law that clearly states that the intermediaries are supposed to take a reasonable effort. Basically, the law I'm referring to is Rule 3, Sub-Rule 1, Clause B of the Information Technology Act. They use the word reasonable effort, but often the intermediaries always interpret the word reasonable effort to merely having some policy mechanism or a terms and condition in their platform. But the same has been rejected by the courts at various points in time. So here we
So,
humbly
is there
contended
any
that
law
this.
to, I just want to add something else here. Is there any law that protects the journalists?
Your Ladyship, if you're essentially referring to the laws that is protecting journalists, would be Whistleblowers Act that protects those people who are exposing the state's anything that has to deal with state or the members of the state who always have the greater power on their hand, and there is a power imbalance. In order to protect those people who are exposing the state, are protected under Whistleblowers Protection Act 2014. In ad
So you could have approached you could have filed an FIR against these people, approached it in an entirely different manner. But because you have approached this honorable bench under the guise of PIL, I'm a little worried because I somehow see that this entire proceeding, it could have gone through some other means, like a criminal.
forums.
Yes. So you could have approached a different forum.
Your Ladyship, the
Rather, you
council would like to
chose.
council like to
Hmm.
certainly, Your Ladyship. Go ahead. Your Ladyship, the Council humbly contend before the Honorable Court that there has been no personal relief that is sought for the interest of Kavya men alone. Here, the interest of general public, basically the interest of the people who criticize the government, and if there is an existing statutory mechanism to address those concerns, the Council humbly presents that the existing statutory mechanism was not gone to an
Has she
extent to
resorted to
prevent such
those
a.
laws? Has she approached the police? Has she resorted to those laws?
Your Lordship, the
Has she
facts are
sought help
extremely
under those
silent on those.
enactments? No,
Your,
because
your,
this is really worrying us, because this platform should not be used for some different purposes, right? So if she could have approached, because as you also agreed that there are various laws that are protecting her in this scenario, why wouldn't she approach? Because
your
79, as
Ladyship,
you mentioned, 79 is in place, IT Act is there. Why PIL? Why not file
your
an
Ladyship,
FIR?
even.
Or why not approach, the relevant forum?
Your Ladyship, it is humbly submitted before the Honorable Court that existing forum does not effectively address the ambit of violation that happens at this point in time. Here, Section 79 allows the particular content to be removed, but again, a special interest group forming a set of a set of
Council, one
the
is
trends.
removing the content, one is filing the FIR under the BNS or the relevant section so that the punishment, they can be punished by virtue of the law, right?
Your
So that
Lordship,
is
at the
one of
instant
the.
case, the factual metrics does not disclose every details, especially in the ambit of whether there has been a other form of approach taken by
Okay.
the Kavya
So,
Menon
Council,
to the
So if
instant.
in
it
your
is not, yes, sir.
Council, in your prayer, you have mentioned defendant. In the cover page, it has been mentioned as respondent. So, can you just clarify?
Yes.
Your Lordship, that is a minor mistake that is made on behalf of the petitioner at this point in time. The council seeks ignorance from the bench on that
And
particular
Council,
aspect.
okay.
But
As point number 3, you asking an independent inquiry, and without having an independent inquiry report, you want us to make them liable? That is the duty of a Supreme Court under the public interest litigation to make somebody liable?
Your Lordship, there is a two concerns that Honorable Bench has raised at this point in time. One is that there is an independent probe that has been requested. Council humbly submit before the Honorable Court. There has been the alleged allegation made by the Kavya Menon is further getting proven or having a positive connotation that the subsequent fact clearly establishes that if any opinion that is against the existing regime could come down on trolling her and especially going on to vandalizing her entire property, including the public functionaries calling her out as anti-national and demanding arrest. And they went on to even share the address. On those particular juncture, the council humbly contends
Because
that
she needed
the
immediate relief.
special
She thought she can. She needed immediate relief somehow to make sure that they are made liable, and that's why she sought relief under PIL. Is that what you're trying to tell us?
Your Ladyship, again, there is a two concern. One is that she's filing a PIL for the purpose of having a special investigation probe, and next is filing a PIL also where the issues
PIL
are
should
already been given
so
by.
is this the only way to request for the special investigation team? Why PIL?
Your, La-
If
Your
you want
Ladyship,
special
again, we are not
investigation team. Yes, please.
we are not contenting that there has to be a remedy for the purpose of Kavya Menon alone. Here, the question is to whether there was
Then
any
why
such a
special
form of
investigation team?
set of group. That is why the question is to find out if there is any state-sponsored mechanism to troll those people who are criticizing the government or
So
critical
you're
of
not
the
sure.
government is
So
existing
you're
or
not
not.
sure. You're not sure if there is something like that existing.
Sure.
You're not
Your
quite
Ladyship,
sure.
again,
There
the
is no
existing
proper.
facts and subsequent facts proves that there is an existence of such a mechanism in place, trolling and or criticizing or harassing people online. But the council wants to further enumerate and prove by the honorable court.
Can you please read it out from your statement of facts? You said that it has been proved through the facts. Can you please mention that in the statement of facts provided by you?
Just a minute. Give the facts. Give the moot proposition. Your relative moot proposition, especially in the contention sorted by the petitioner in the instant case, in the para 4 very clearly illustrate that an independent probe into the alleged state-sponsored trolling machinery and direction to the government to regulate political use of social media. Here, the para 4 of the moot proposition clearly establishes the same.
Can you please read the entire thing? The entire paragraph.
On 15th April 2025, a group of citizens, including journalists, activists, lawyers, filed a public interest litigation before the Honorable Supreme Court of Aryavata, seeking an independent probe into alleging state-sponsored trolling machinery.
That is what you've asked. That is what your clients have asked. You said it has
Your
already
Lordship, the
been
moot
proved.
proposition.
You said it has already been proved, right?
Your Ladyship, the council humbly contends that the subsequent facts after the publication of book has resulted in the verified political party functionaries calling her anti-national and additionally sharing her address to an extent that the group of mob comes out to vandalize her entire property, and that proves that the allegation made by her is getting substantiated. To addition to inquire into those instances, the council humbly seeks a special investigation probe.
So without a special investigation, how can we hold that they are liable? That is what my brother judge also asked you.
Your Ladyship, again, we are not considering a chip incorporation held liable for the purpose of not having to prove that there is a special, a state-sponsored mechanism. Here, chip incorporation has to be held liable for violating the existing law, and it proves that even if your Ladyship, if you look at the moot proposition, especially para number 6, it clearly helps that it has a robust reporting mechanism and community guidelines, and they are not liable for the political content will destroy the principle of safe harbor and real misuse of freedom of speech by the user, not the platform's failure. Here, they agree that there is a misuse of freedom of speech in their platform. The chirp incorporation has to be held liable for existing violation of existing laws. But rather, we are having a special investigative probe for alleged, or basically there is an existing state sponsored mechanism to harass the people. So here the state is a different entity and the chip is a different entity we are dealing with. Here we are dealing with this SIV, the special investigation probe.
Yes. Okay, so you say defendant number 1, or in this case respondent, as you say. Who are these people? Who are respondent number 1?
Respondent number 1 is Union of Aryavata.
Union of Aryavata.
And
right? So you want the Union of Aryavata to be held liable because they conducted an online abuse through their supporters.
Certainly, Ladyship. Again, the council, in the fear of reiterating the same contention made by the first council, we humbly contend that the volunteers are becoming existing members of the political organization GSP, and GSB has been equated to the instance of state to an extent where they have an existing underlying nexus between the both.
My small doubt here is, why do you want to make Union of Aryavarta liable here? Because these are two different things. I know that you have quoted that um, uh, this ruling party is taking a lot of benefits and all that, but the unofficial party structures that you mentioned later are not part of that system. The trollers are not part of Union of Aryavarta. If they are being funded by a particular party, why wouldn't you make the respondent as that particular party? Why wasn't JSP the respondent?
Your ladyship, accepting to the concerns made by the honorable bench, that assuming but not accepting to the concerns, it is humbly submitted that even if the JSP is not equated to the Union of Aryavarta, it is again the positive obligation imposed upon the state to further protect the freedom of, especially the fundamental right of the citizens,
But then why do
regardless
you
of who is
mention Union
violating the
of
same.
Aryavarta? Union of Aryavarta and another, right?
Your ladyship, Union of Aryavata here contended to equate JSP, and the same contention has been already made. But another, basically, the respondent number two is basically CHIRP Incorporation, because in the factual metrics, the CHIRP Incorporation has seek to intervene. They themselves came inside into this particular case by way as a respondent, because the fact para 6 clearly says that, let me read it out, your ladyship. The global social media company CHIRP Incorporation, a fictional Twitter-like platform, seeks to intervene. So basically, they themselves have come forward to intervene, to argue, stating that their interest is at stake and somehow. But counsel humbly content to the certainly, your ladyship. The ladyship is satisfied with the clarification brought by the counsel. The counsel like to rest the argument. If there is
Yes.
any clarification sought by the lordship or ladyship, the counsel is happy to answer. In the absence, the counsel like to rest the argument. Much obliged, your ladyship. It was indeed a great pleasure arguing before the honorable bench.
Can we start with the respondent's argument?
Greetings to the bench. May the counsel begin with the respondent side?
Yes.
May it please this honorable court. This is the first counsel appearing along with my co-counsels on behalf of the respondents before this honorable court in the case of Kavya Menon and others versus Union of Aryavarta and another. The counsel seeks permission to address the bench collectively as your lordships and individually as your ladyship and your lordship.
Yes.
Much obliged, your lordship. With that, may the counsel begin with the contentions.
Yes.
Much obliged, your lordship. The counsel for the respondent has 5 contentions to place before this honorable court. Firstly, the alleged coordinated online trolling campaigns do not constitute a state actionable violation of fundamental rights under Article 14, 19, and 21 of the Constitution. Secondly, that the state cannot be held accountable for the alleged online abuse by non-state actors through unofficial party structures. Third, imposing further restrictions on political use of social media would amount to an unreasonable restriction under Article 19(2). Then fourth, CHIRP Incorporated cannot be held liable for failing to prevent abuse in light of Section 79 of the IT Act. And fifth, investigative journalism making unverified allegations of state-sponsored trolling constitutes defamation and is not protected by the freedom of the press. Of these 5 contentions, the first 3 will be dealt by myself, and the final 2 contentions will be dealt by my co-counsel. With that, with your lordship's kind permission, may the counsel begin with the first contention?
Yes.
Much obliged, your lordships. It is humbly submitted that the alleged online trolling campaign would not amount to violation of fundamental rights that could be enforced against the state, your lordships. Firstly, the council would establish this using 3 grounds. Firstly, that the bill that is filed is not maintainable. And your lordship, it is humbly submitted that the petition seeks to hold the state accountable for protected speech and independent actions of private citizens. Your lordship, the harms that is alleged by the petitioners, which includes threats and harassment and defamation, these are cognizable offenses for which there is already a framework of remedies available under the law. for instance, any aggrieved person, if it is Kavya Menon or any other aggrieved person, could file an FIR before this police, as your lordship had mentioned earlier, and also they could file a complaint in the National Cyber Security Portal maintained by the government. Also, your lordships, the BNS 2023 as well as the IT Act deals with specific online offences, and also the complainants could also approach the nodal agency for the with the concerned social media platform regarding removal of any such content, your lordships. And also it is also submitted that the impugned online speech is protected political expression under Article 19(1)(a). Your lordship, while a journalist like Ms. Kavya Menon has the right to criticize the government on the one side in her book, the others also have the right to criticize her for her work. And further, your lordships, any restriction that would be imposed on freedom of speech under Article 19(2), for that the speech has to meet a high threshold as laid down in the Shreya Singhal judgment, as reported in the All India Reporter in their 2015 in the Supreme Court, page number 1523. And the online posts cited by the petitioners, they do not meet this high standard, high threshold, and demanding her arrest or labeling Ms. Menon as anti-national by a few verified party functionaries. These are, your lordship, forms of political opinion, and they are not a call to imminent violence. And also, the petitioner's entire bill is premised on the fact that the entire state is accountable for the action of private individuals. And we humbly submit that this is not permissible due to several reasons. First is that the rights under Article 14 are available against only the state. Your lordships, the verbatim of Article 14, that is the Article 14 states that the state shall not deny to any person the equality before the law or the equal protection of laws within the territory of the Union of Hyderabad. And in the present case, the online harassment and the threats faced by Ms. Kavya Menon, they are attributed to private individuals online. And some of them were a few verified party functionaries. And this is an association, a voluntary association. And these entities do not come under the definition of state under Article 12 of the Constitution. The Council would like to explain this contention in the second contention, your lordship.
Please proceed.
Indeed, your lordship, that also the petitioners had cited two judgments, the case, Pottaswamy case, the Union of India in 2017, and as well as the Kaushal Kishore versus State of Uttar Pradesh, as reported in the Supreme Court cases in the year 2023, volume number 4, page number 1. And regarding the horizontal application of fundamental rights. However, in the Kaushal Kishore judgment, your lordships, the Supreme Court held that when the author of a violation of a fundamental rights is a non-state actor, the action would lie at a common law court or an ordinary court. And hence it is most humbly submitted that the petition is seeking a constitutional remedy against the state for what are private wrongs, your lordship. If your lordship is satisfied with the first contention, may the council move on to the second contention?
Yes, please.
Much obliged, your lordship. It is most respectfully submitted that the state cannot be held liable for acts of online abuse attributed
We
to
agree with the first point, especially because the petitioner has the argument that the petitioner has made regarding the government failing to enact the legislation is not there as part of their memorial. So I think we'll be taking your argument. So you can proceed to the second issue.
Much obliged, your ladyship. And your ladyship, in the instant case, your lordship, we have submit that the state cannot be held liable because we are explaining this using three grounds. That firstly, that the digital cell or the individuals, the verified party functionaries, they do not qualify as state or an instrumentality under Article 12. And Article 12 states that the state includes the government and the parliament of the country, then the government and the legislatures of the states, and any local or other authorities within the territory of the Union of Aryavarta or under the control of the government. And this term called instrumentalities, this has been elaborated in several other cases as well. For instance, there is the R.D. Shetty case and Ajay Hasya versus Khalid Mujib Sarawardi. And also, the court had.
So, council, you have a reservation only with respect to Article 14, but Article 19 and 21, there can be horizontal application. which can be exercised against a private individual also?
Indeed, Your Lordship, they can be enforced against the private individual as well. But however, relying on the judgment in Kaushal Kishore versus State of Uttar Pradesh, as I had mentioned earlier, which instead had relied on the judgment by Justice Chandrachud in Puttaswamy case, where the author of a violation of a fundamental rights is by a non-state actor, the action against that would lie at an ordinary law court. That was what the judgment held, Your Lordship. Your
Okay.
Lordship is satisfied. May the council continue with the contention? Your Lordship?
Yes, please.
Much obliged, Your Lordships. Also, Your Lordships, the cases that were cited regarding Article 12, Ajay Hasya case, where the court had laid down certain conditions, had summarized certain conditions, where as questions of whether the body could be considered state or instrumentality, and they would, such as the share capital held by the government, deep and pervasive state control. There are 5 conditions. And later in Pradeep Kumar Bishwas versus Indian Institute of Chemical Biology, as reported in 2002 in the Supreme Court cases, in volume number 5, page number 111, the court held that when such a question arises, the court will have to consider the cumulative facts, and the body has to be financially, functionally, and administratively dominated by the state. And in page 134 of that judgment, it states that even if the control is merely regulatory, it would not make the body state. And it is humbly submitted that mere proximity or a person being a party functionary cannot convert the liability. It cannot be vicariously attributed to the state.
Counsel, with respect to public interest litigation, in the public interest, can the court ignore certain technicalities? Maybe we can take up only Union of India for the purpose of Article 14, 1921, and we can include that political party for the respective other issues. In the public interest, whether that is allowed. And I think courts have done away with certain technicalities in the public interest. That is the basic objective of PIL.
Indeed, Your Lordship. However, in the instant matter, what we have are certain people, and it is not even mentioned all of the people involved are the party functionaries. As per the statement of facts, it states that a few verified party functionaries openly called her anti-national. One of them released her address, and this cannot be attributed to the state. That is what the petitioner is, the respondent is humbly contending, Your Lordship. And also, for state to be made liable, as Your Lordship had just mentioned, regarding the PIL, for ignoring the technicalities, for state to be made liable, there has to be some sort of evidence showing that the state had directed or facilitated the online abuse. And in the instant matter, the communications of the individuals, they were not made as representative of the states. And the council would also place reliance on the case of Ramleela Maidan incident versus Home Secretary Union of India, as reported in the Supreme Court cases in the year 2012, volume number 5, page number 1. And this case was regarding the effective control theory, that is, which is a sine qua non for attributing impunity act to the state. And the Honorable Supreme Court, in that case, the court had imposed liability on the state because the persons involved were police officers who were acting under direct governmental command, who employed excessive force. And the court had emphasized that the attribution arose only because there existed a clear chain of command and authority linking the particular act to the state. And in the instant case, Your Lordship, there is no such relationship of command or authority between the state and the non-state actors who did the online abuse, Your Lordship. And also, the council would also like to state the case of Kaushal Kishore versus State of Uttar Pradesh again. And one of the questions before the court in that case was whether, regarding hate speech, whether a cabinet minister could be held, apologies, Lordship, whether the government and the entire council of ministers could be held responsible for the hate speech made by a cabinet minister. Regarding collective responsibility, and the court in the constitution bench judgment, the court had categorically held no. That is, the minister, the liability would lie only on the minister and not to the entire government.
Also, in this particular case, it is not about the collective responsibility; it is about the duty of the state, the primary responsibility of the state. In case hate crimes are increasing, what is the problem? Either the mechanism is weak or the laws are inadequate. So in that respect, PIL has been filed, and we can direct the government to take more proactive step or to come up with certain solutions so that this incident does not happen. It
Indeed,
is
Your
not
Lordship.
that for everything, certainly the government can be held responsible because ultimately they are running the country or a right?
Indeed, Your Lordship. Indeed, Your Lordship. May the council answer that query?
Yes.
Indeed, Your Lordship. The council would like to address that issue in the very next in the very next contention. May the council first conclude this, what I meant by this Kaushal Kishore case, Your Lordship?
Yes.
Much obliged, Your Lordships. Firstly, in the Kaushal Kishore case, what was that? The government could not be held liable for the acts of a minister. Similarly, what we submit is that the entire ruling the government cannot be held liable for actions of certain verified party functionaries who have done something based on their own personal things, Your Lordship. And to answer Your Lordship's query regarding the adequacy of the laws existing in the country, may the council begin with the third contention?
Yes, council just want to clarify, if in a particular state law and order is a state subject, ultimately the government is liable. If a murder happens, the state won't be given death penalty for the murder of a particular person, but regulating law and order, that is the responsibility of the state.
Indeed, Your Lordship.
So in that aspect, the state can be held liable to make certain guidelines for the act or maybe for the omission, right?
Indeed, Your Lordship. That is the very submission of the respondents. That is that the existing legal frameworks, as part of the third contention, Your Lordship, the existing legal frameworks is sufficient to address the online harms, Your Lordship. First of all, what the petitioners have stated, the petitioners' plea for new regulations, they start from the premise that there is a legal vacuum in the Union of Aryavarta regarding online abuse and hate speech. However, Your Lordships, what the respondents contend is that already there are several comprehensive framework of laws to combat the specific harms. And once again, citing Kaushal Kishore judgment, Your Lordships, in the judgment, the Supreme Court had created an entire table regarding the provisions regarding hate speech within the Indian Penal Code. And now the IPC has been replaced with the BNS, and the specific harms alleged in the petition are addressed in the existing penal law. First, we have the hate speech, which are dealt with in sections 196 and 299 of the BNS, the defamation under 356, section 356 of the BNS, criminal intimidation under section 351, section 74 and 79 for offenses against targeting the modesty of women, then section 103, subsection 2, which deals with
Okay,
mob
council.
lynching.
So the thing is, there are number of laws, right?
Indeed,
Adequate
indeed,
number
Your
of laws, but maybe the government intent is not there, or the mechanism or the implementation is not proper. That's why these incidents are keep on happening. Even then, the PIL can be filed. We can direct the government to take the necessary steps or action.
Indeed, Your Lordship, that is admitted by the respondent. However, the problem with what the petitioners have been seeking, Your Lordship, as per the Moot proposition, as per the arguments of the petitioners, what the petitioners seek is the regulation of political use of social media. And this is even if such a law is made, even if the Supreme Court directs us to create such laws, and even if such a law is made, it would be a censorship kind of law, Your Lordship. It would restrict speech completely, and the scope would not be exactly defined. And also,
Council, in case it will restrict the speech completely, that won't fall within the reasonable restriction, because restriction has to be reasonable. Then that constitutionality can be checked by the court. So they are focusing not on the control rather than regulation. And
Indeed,
each and
Your
everything can be regulated, right?
Indeed, Your
When we have a
Indeed, Your
censor board for the movies, why we cannot have some kind of regulation for social media?
Indeed, Your Lordship. However, even if such laws are made, what the petitioners seek is laws regarding online abuse, trolling, misinformation, and Your Lordships, such terms, for instance, the misinformation or trolling, these are not exactly objective words. That is, they are very subjective words. For instance, Council would like to paraphrase from the judgment in Shreya Singhal versus Union of India, where it was regarding section 66A, that is where the court had struck down terms such as causing gross annoyance or inconvenience and something that is grossly offensive, grossly offensive, they were struck to be declared to be unconstitutionally vague and overbroad, and hence Section 66A was declared to be unconstitutional. And in the instant case as well, even if such laws are made, the misinformation, trolling, they would also be really vague and overbroad, Your Lordship. And also, speaking about the subjectivity of these terms, Your Lordships, the terms one person's trolling would be another person's political satire.
Okay, Counsel, understood you have limited time left, so please complete your arguments accordingly.
Indeed, Your Lordships. Also, regarding the council would also like to cite a case, very recent case in 2023, regarding the 2023 amendment to IT rules, and where the government had made certain regulations for the intermediaries under IT rules, that the intermediary will have to remove content which the fact check unit of the government would find as fake, false, or misleading, and the Bombay High Court had declared this law to be unconstitutional because the terms fake, false, and misleading were subjective and overbroad. And in the instant case as well, the regulation of political use of social media, and these would also be very subjective, Your Lordship, and exactly what constitutes a political use of social media, because on social media everything is political and individuals have their own politics and they have the right to express.
Understood. Just summarize your arguments.
Indeed, Your Lordship. Much obliged, Your Lordships. And as the council had explained, there are several other laws in place, including the DPDP Act of 2023, which has come into force 1 week prior to this day, that is on 14th November. And they have the provisions regarding doxing. That is the one of the issues raised by the petitioners was that her address was leaked online.
Counsel, if you have anything additionally to speak, you may use the time given to you in
Indeed, Your Lordships. It is most humbly submitted that the laws demonstrated the state is not a passive bystander, and we have been engaging.
The time is running. Are you sure you want to utilize the time given to your co-counsel?
It is not. I'm concluding my argument, Your Lordships, and it is most humbly submitted that the political use, regulation of political use of social media would be an unreasonable restriction under Article 19, Your Lordships. And with that, may the council yield the floor to my co-counsel. Your Lordships, may the council yield the floor to my co-counsel.
Yes.
Much obliged, Your Lordships. It has been an honor pleading before this bench.
I hope I'm audible, Your Lordships.
Yes, you are.
May it please His Honorable Court, this is the second counsel appearing along with my co-counsels on behalf of the respondents in the case concerning Kavya Menon and others versus Union of Aryavarta and another before the Honorable Supreme Court of Aryavarta. The council seeks permission to collectively address this bench as Your Lordships and individually as Your Lordship and Your Ladyship.
Yes, continue, please.
Much obliged, Your Ladyship.
Directly move to the issue.
Indeed, Your Lordship. This council will be dealing with the final two issues in the present matter. Moving on to the fourth contention, addressing the fourth issue, the counsel for the respondents humbly submits before this honorable court that Chirrup Incorporated cannot be held liable for failing to prevent abuse in light of Section 79 of the IT Act 2000. Elaborating upon the same, the council would like to draw Your Lordship's attention to the fact that in the present matter, Chirrup Incorporated is merely an intermediary which provides a platform for user interaction and posting of content. Now, this squarely falls within the definition of an intermediary under Section 2, subsection 1W of the IT Act. Now, to further substantiate the council's argument, the council would like to rely upon the case of Kunal Kamra versus Union of India, Bombay High Court judgment, writ petition number 9792/2023, wherein it was held that a bare reading of Section 79, subsection 1 and subsection 2 indicates that the protection from liability is in cases where service providers act as a mere conduit. Now, Your Lordships, applying the same to the present matter, it is pertinent to note that Chirrup Incorporated in the present matter is a neutral platform for the users to post their content, and they do not have any knowledge or control over the user-generated posts. Now, this in itself places them as a passive intermediary in the present matter, Your Lordships, as the platform itself does not create the content, it just facilitates its transmission. Now, Your Lordship, To substantiate as to why Chirrup Incorporated is entitled to safe harbor protections in the present matter, the Council would like to draw your Lordship's attention to Section 79 of the IT Act, particularly Section 79, subsection 2 of the IT Act. Your Lordships, in that particular...
Please come again. You just mentioned that Chirrup doesn't post, rather it is only giving a platform, right?
Your Lordship, Indeed, your Ladyship.
Can you please repeat that sentence?
Indeed, your Ladyship, what the Council was trying to establish was that in the present matter, Chirrup Incorporated is a passive intermediary. And the reason to establish the same is that the platform itself does not create the content. It does not do anything with the content. It is the users who
But benefits from the content.
Indeed, your Lordship.
Benefits from the content, right? And what is the crux of 79 IT Act? Why do you think that particular section was introduced?
Your Ladyship, it was introduced to provide safe harbor protections to intermediaries for the content posted by third parties or the users of their platforms. Your Ladyship, particularly Section 79, subsection 2, clearly and explicitly states that these intermediaries shall be entitled to safe harbor protections only if the function of the intermediary is limited to providing access to a communication system, or the intermediary does not initiate the transmission, select the receiver of the transmission, and third point, select or modify the information contained in the transmission. Your Lordship, in the present matter, it is pertinent to note that all these elements are being fulfilled by Chirrup.
The whole idea is whether there is any due diligence.
Indeed, your Lordship, there is due diligence as stipulated under Section 79, subsection 2C of the IT Act, and in itself, it is also there in Rule 3, Sub-Rule 1.
Can you please tell me where is the due diligence here in this case?
Indeed, your Lordship. Your Lordship, to answer upon the same, the Council would like to draw your Ladyship's attention to paragraph number 6 of the Moot proposition. Your Ladyship, now para 6 of the Moot proposition clearly states that Chirrup Incorporated has robust reporting mechanisms as well as community guidelines. Your Lordship, this in itself shows that they have exercised due diligence and have taken all reasonable efforts.
Just because they have a team doesn't mean they have taken precaution. Just by nominating that, I have a list of people who are already been nominated as a team. See, to ensure that the team is working is a duty of Chirrup Incorporation. And in this present case, they have failed. They have terribly failed.
Indeed not, your Lordship. Your Lordship, in the present matter...
the Council, please, I think if you can read the fact sheet, there are some sensitive information that has been put in the platform, and the failure of the team to identify it led to the mob reaching the author's house, right? Leading to the harassment. All of this would have been prevented to a large extent if this reporting mechanism or the team which was appointed by Chirrup Incorporation would have worked, right? So if there was any kind of contribution by the team assigned, this entire incident wouldn't have happened, don't you think?
Your Ladyship, the Council very much understands your Ladyship's concern. However, the Council begs to differ. Your Ladyship, the reason for the same is that in paragraph number 6 of the Moot proposition, it is clearly stated that Chirrup Incorporated is an intermediary which is alike to Twitter. Now, Twitter comes within the ambit of significant social media intermediary, which means that it has over 5 million users, your Ladyship. Now, constituting a team and going on with each post posted by the users is technologically impossible, your Ladyship. And further,
it's
if
definitely
doing this
possible, especially with the AI intervention. Technology is being used even in the e-commerce reviews, all kinds of. There are various platforms available where they can even create reviews, and they can even identify if there are any kinds of fake reviews. When the technological advancements can be used while the commercial aspect is involved, why not in these cases?
Indeed, your Lordship. Your Ladyship, in the present matter, use of AI or other technologies can be used very prominently. But again, one concerning matter in the present case is that it will lead to an active content moderation, which will create a chilling effect to the freedom of speech and expression of the users as well, your ladyship. And see again, your ladyship, what your ladyship was addressing was with regard to the publishing of Miss Kavya Menon's address in the particular platform. Your ladyship, now sexually explicit content, prohibited content, content which explicitly states about child abuse or rape, such content can be defaultedly auto-blocked under these community guidelines, your ladyship. However, using the same to identify whether this address and all is technologically impossible, your ladyship, because again, it is hard for AI to detect whether this particular post mentions the address of a person or not. So that is to be
Are you
taken into
sure that
consideration,
the
your
AI
ladyship.
cannot, no, counsel, because you have to be very careful when you're making the statement before the bench, because you are telling me that the AI is not capable of identifying hate speech.
Your ladyship, what the council is intending to state here is that the AI is capable of identifying sexually explicit content, but with regard to
Not
hate
the hate
speech,
speech.
hate speech differs from person to person, from language. If we take into consideration Aryavartha itself, it's a
This
huge
council
platform.
here, we are concerned about hate speech that has instigated mob to reach the house of the author.
Indeed, your ladyship.
And all of this was present on your platform.
Indeed, your
Entire
lordship.
instigation happened on your platform, isn't it?
Indeed, your lordship. However, ladyship, there is a plethora of cases, including the Sabo Matthew case, which has explicitly stated that intermediaries in that circumstances shall not be held liable.
So you just want to say that we are not liable?
Your leadership, it is technologically impossible to connect the same, your leadership, because hate speech and all, there are various keywords, and we could only act upon actual knowledge, not upon constructive knowledge. Now, actual knowledge again is one of the vital points which is mentioned under section 79.
Can you tell me what is due diligence? Can you define due diligence?
Your ladyship, due diligence is subjective in nature and it differs from
Can you define due diligence?
Your ladyship, due diligence, if according to me, will be taking reasonable efforts
No,
in such a way as a plausible.
Define it.
Counsel, for everything is subjective, right? What is reasonable to me might be different from somebody. But what my learned judge, a fellow learned judge is asking, whether any jurist, any dictionary, any statute has defined this due diligence.
Your leadership, IT rules 3 explicitly mentions due diligence.
Is your act satisfying the requirement under due diligence?
Your leadership, due diligence again. Your leadership, even if we take into consideration Rule 4, Sub-Rule 4 of IT Rules 2021, it asks for the deployment of automated tools to prohibit the content which are explicitly, your leadership, which is sexually explicit, or content which exhibit rape or child abuse. Your leadership, in the present matter, indeed, your leadership, we have community guidelines and reporting mechanisms, and these community guidelines can be explicitly used to block the same, your leadership. How with regard to hate speech, there is nothing mentioned either in the IT rules or IT Act considering the same, your leadership. If your leadership is satisfied, may the council revert back to her contention.
Not satisfied, but you may proceed.
Much obliged, your leadership. Now, what the council was trying to establish before this honorable court is that your leadership, your lordships, the respondents can only act upon actual knowledge of the incident, and it is an intrinsic element under section 79 subsection 3 of the IT Act 2000, as well as very recently the IT Amendment Rules 2025 came into force just 1 week before, your leadership. Particularly Rule 3 Sub-Rule 1D of IT Rules 2021, which came into effect from 15/11/2021, explicitly states that actual knowledge shall arise only under 2 circumstances. Your leadership, first is by a order of court of competent jurisdiction, and second is by a recent intimation in writing by an officer authorized for this purpose. Your lordships, in the present matter, it is pertinent to note that this element of actual knowledge is very it's something which is of utmost important, as when intermediaries act upon constructive knowledge, it may lead to moderation of user content, which violates the fundamental rights guaranteed to the citizens or the users of these platforms under Article 19 and 21 of the Constitution. Further, your lordships, the council would also like to draw your lordships' attention to Rule 3, Sub-Rule 1N of IT Rules 2021, which explicitly states that intermediaries shall respect all the rights accorded to the citizens under the Constitution, including Article 14, 19, and 21. Now, your lordships, this intermediary should not be left with the task whether to identify a content is infringing or not, because it cannot act upon the same. It will create a chilling effect on its fundamental rights under Article 19 and 21 of the Constitution. So in order to protect the rights of both the citizens or the users of the platforms as well as the intermediaries itself, this honorable court is pleased to take such a consideration, your lordships. Therefore, the council would also like to draw your lordship's attention to the security obligations under Section 43A of the standards like ISO IEC 27001, which requires intermediaries to ensure reasonable security practices for the protection of personal data and not to undertake a pervasive monitoring of the user-generated content. Therefore, your lordships, it is most humbly submitted that Chirrup Incorporated cannot be held liable for failing to prevent abuse in light of Section 79 of the IT Act 2000. Now, if your lordships have no further queries with regard to the council's fourth contention, may the council kindly move on to the fifth issue.
Okay.
Much obliged, your lordship. Moving on to the final issue in the present matter, the counsel for the respondents humbly submits before this honorable court that investigative journalism making unverified allegations of state-sponsored trolling constitute defamation and is not protected by the freedom of press. Now, elaborating upon the same, the council would like to rely upon the fact that freedom of press has been from a very prolonged period been identified as a fundamental right under Article 19 of the Constitution, starting from the landmark judgment of R. Rajagopal versus State of Tamil Nadu, reported in the year 1994 in Supreme Court cases, volume 6 at page 632. Even in that particular case, the Honorable Supreme Court in itself has drawn a clear line of difference between legitimate press activity as well as defamatory publication by stating that while press is free to publish matters of public interest, it has no right to publish false or unverified allegations. Now, connecting this to the instant matter, your lordship, the council would like to draw your lordship's attention to paragraph number 2 of the Moot proposition. Your lordship's paragraph number 2 of the Moot proposition contains the contents of Ms. Kavya Menon's book, who is one of the petitioners in the present matter. Your lordships, in it is specifically mentioned that in it, that is in her book, she alleges so and so. Again, your lordships, these are all based on mere allegations. And one concerning factor about this is, in the same paragraph, it is given that journalists like Ms. Kavya Menon constitute investigative journalists. Now, your lordships, investigative journalism is quite different from normal course of journalism, and this has been substantially observed by UNESCO as well, wherein UNESCO has stated that the council quotes, investigative journalism involves exposing to the public matters that are concealed either deliberately by someone in a position of power or accidentally behind a chaotic mass of facts and circumstances that obscure understanding, which requires both secret and open sources and documents. The council unquotes. Your lordships, from this, it is quite clear that investigative journalism focuses on documents like closed source documents as well as people, that is whistleblowers. Now, your lordships, one problem with this is that these journalists can come up with any journalistic pieces claiming that these are investigative journalism. They cannot disclose the elements in the book. Your lordship, in the present matter also the same has happened. Whatever is been mentioned under para number 2 of the Moot proposition, all these are allegations, and they cannot hide under the guise that this all comes under investigative journalism, and they cannot disclose the credible evidences to substantiate the same. Now, your lordships, it is pertinent.
So does the council want to state that whatever action was taken against the author was right, or they had the right to express, on the platform? Your client platform about the book written. Is that what you're trying to say?
Your lordships, the councils for the respondents is representing for Union of Aryavartha as well as First Europe Incorporated. We are not making any
Understood.
comments about whatever has been posted on online. However, it is to be brought to the attention of this honorable court that whatever comments have been posted is clear that apologies, your lordships, whatever contents of the book has been published, it is particularly pertinent to note that all these are allegations. Now, what happens in this case is that it is directly defaming to the JSP party. We are not here representing the JSP party, but the core issue.
Why are you making that contention?
Your ladyship, let me address the same, your ladyship. Just 2 seconds, your ladyship. To substantiate the same, the council would like to bring to your ladyship's attention that investigative journalism without any credible sources, what can happen? Today it is against JSP party people. Tomorrow it can be against opposite party, your ladyship. So what is a bigger picture here is that it is affecting the citizens as a whole. Investigative journalism without any credible evidences affect citizens as a whole, and under Article 19 Clause 2, this is a valid ground, your ladyship. Therefore, reasonable restrictions can be imposed. That is, freedom of press is subject to reasonable restrictions under Article 19 Clause 2 of the Constitution of Aryavarta. To substantiate the council's argument, the council would like to rely upon the very recent judgment.
Under which specific reasonable restriction you want to restrict this under 19 Clause 2?
Defamation, your lordship.
Okay. Continue.
Much obliged, your lordship. Reverting back to the council's contention, the council would like to rely upon the case of Subramanya Swamy versus Union of India, reported in the year 2016 by Supreme Court Cases at volume 7, page 221, wherein it was held that the council quotes, reputation is an integral part of dignity, and the freedom of speech cannot mean the freedom to cause injury to another person. Your lordships, this even applies to investigative journalism as well. To substantiate the same, the council would like to rely upon the recent judgment in Kanjan Jagadish Kumar Thakur versus Wahid Ali Khan, wherein it was held that the council quotes, investigative journalism definitely does not enjoy any special protection, and the umbrage of public interest definitely do not permit a publication which would amount to lowering down the reputation of any person in any manner, particularly without justifying the publication on the basis of its truthfulness. The council unquotes. Your lordships, on the basis of the same, the council for the respondents most respectfully submits before this honorable court that investigative journalism making unverified allegations of state-sponsored trolling constitute defamation and is not protected by the freedom of press. Now, if your lordships are fully satisfied with the council's arguments, may the council proceed to the prayer.
Council, just one quick question. How you can distinguish or have a distinction between what is verified, what is unverified?
Your lordships, addressing your lordship's question, what is verified and what is unverified can be proved only if these journalists come up with credible sources. Your lordship, in the present matter, what is happening is that they have relied upon investigative journalism. Investigative journalism, particularly when it in itself is based upon closed sources and whistleblower narratives. Now, your lordships.
Coming to that aspect, what are the characteristics of credible sources? As to what can qualify that this information has been derived from the credible sources?
Your lordship, if it is supported by fair reports, if it is if it is based on true values and true facts, then the same shall be entertained, your lordship. We are not disputing anything about that. They journalists, we do appreciate journalists to express their fair right of criticism. We are not disputing anything about that. Unless
come to your prayer.
Indeed, your lordship. Wherefore, in the light of issues raised, arguments advanced, and authority cited, it is prayed that this Honorable Supreme Court of Aryavartha may be pleased to adjudge and declare that, firstly, the PIL filed in the instant matter is not maintainable. Secondly, that the alleged coordinated online trolling campaigns do not constitute a state actionable violation of fundamental rights under Article 14, 19, and 21 of the Constitution of Aryavartha. Thirdly, that the state cannot be held accountable for alleged online abuse by non-state actors through unofficial party structures. Fourthly, that the restrictions on political use of social media would amount to reasonable restrictions under Article 19, Clause 2 of the Constitution. Fifthly, that the Chirrup Incorporated cannot be held liable for failing to prevent abuse in light of Section 79 of the IT Act. And finally, investigative journalism making unverified allegations of state-sponsored trolling constitute defamation and is not protected by the freedom of press. And this Honorable Court may be pleased to pass any other order, direction, or relief that this Honorable Court may deem fit in the interest of justice, equity, and good conscience. And for this act of kindness, the counsel for the respondents shall duty bound forever pray. It was an honor pleading before this bench.
If your lordship may permit, the counsel on behalf of the petitioner would go on with the rebuttals.
Yes.
Okay.
Much obliged, your lordship. The argument pertaining to the maintainability of the petition on the ground that all remedies haven't been exhausted and the private interest cannot be satisfied, established as a PIL, is not tenable on two grounds, as earlier demonstrated. Firstly, that the PIL can be filed when the existing law fails to prevent the fundamental rights transgressing as held in the Society for Enlightenment versus Union of India case. And secondly, that all remedies need not to be always exhausted to approach the Honorable Court under PIL as established in the Kavalapakar Kotali versus the state of Madras and others. With regards to the contention that the PIL is based on allegation and therefore baseless, the council humbly contend that the PIL is based on the facts and not merely allegation. The mere pursuit of the fact indicates that the verified political functionaries did make a hateful statement and incite violence towards Mrs. Menon, indicate that the presence of an online entity that harasses individual for their political stance. The third would be the next. The impugned speech is not protected under Article 19, Clause 1A. The argument that these comments are only political opinions are untenable, and the case of Amish Devgan versus Union of India clearly lays down that hate speech leading to discrimination cannot be constitutionally tolerated. Similarly, any dispute that present does not meet the threshold of incitement is invalid. As demonstrated through the case of Shreya Singhal versus Union of India, which defined incitement and Simon Wickens as prosecutor, it clear that when a speech, even if made indirectly, was understood by the target audience and violence ensued, it would amount to incitement, and the same has occurred here. In the facts in Para 7 clearly demonstrate the casual link between the post and the vandalism. The scene sense, the political functionary referred to Ms. Menon as an anti-national and showed hostility towards her. Secondly, the same functionary leaked her address and targeted audience according to committed vandalism on her property. This established the incitement to violence has certainly taken place. Argument made in the light of the issue 5 has been based on erroneous assumption that the issue deals with a book written by Ms. Menon. However, the council would like to contend that the issue at larger deals with the scope of investigative journalism, not merely to the findings made by Mrs. Menon. The interpretation by the respondent that the allegation was made by Menon is automatically false and inappropriate. The duplicity of her allegation can only be tested based on the individual litigation deliberated on the source of her contention, and therefore it cannot be said that the face of the matter that all contention made in her book are false in nature. In addition to that, the council like to submit before the Honorable Court that Chirrup Incorporation has always been claimed to be merely a neutral party and a passive intermediary. But Delhi High Court has very clearly rejected this same defense claimed by the intermediaries in Aradhya Bachchan versus Union of India judgment, stating that the intermediaries cannot have a hands-off approach, and as per the application of law post amendment to the IT rules 2021, after 2022 amendment and 2023 amendment, that they must have more proactive role. In addition to that, often it has been contended by the petitioner that it is technologically impossible. But if the same thing is in the interest of commercial interest, they often come around restricting the host of that particular content on the platform. If the same thing is blatantly visible that there is a violation, especially posting a sexually explicit content, and the same cannot be here removed. At the same time, the existing mechanism that they claimed by the petitioner at this point in juncture does not hold any validity, as they have made an informed choice not to act, as the council like to draw the attention of the Honorable Court to the para 6 of the Moot proposition, they have made the informed choice in spite of knowing that there is the existence of abuse taking place in their platform. That shows that they have the actual knowledge of the content in their platform. In addition to that, Kavya Menon is not a petitioner at this point in time, as the facts of the factual metric clearly establishes that the Kavya Menon is not the one filing petition, and there is a bystander on the argument made by the council on behalf of the respondent that in third issue they have claimed that the coordinated online trolling does not constitute public order, but in para 100 of the very last line of their argument in the fifth issue, they have claimed that the publishing book does not having verified content causes public disorder. These are the contentions made before the Honorable Court as a rebuttal. The council would like to rest the rebuttal argument, Your Lordship.
Am I audible, Your Lordships?
Yes.
May the council start with the rebuttals? Much obliged, Your Lordships. Now, Lordships, primarily, the council would firstly like to establish as to why Kavya Menon is invoked as petitioners. Your Lordships, the clarifications released upon this Moot proposition, particularly point number 2 of the clarifications explicitly says that Kavya Menon can be considered as one of the petitioners, Your Lordships. And that is the same reason why Kavya Menon here is the petitioners, and we have included the same in the case title of our memorial as well, Your Lordships. Now, particularly regarding to the content of the books of Ms. Kavya Menon again, point number 5 clearly states that, point number 5 of the clarifications clearly states that all the contents of the books are still disputed and it is not verified, Your Lordships. Now, the third point which the council would like to present before this honorable court is that we have not stated that PIL should be rejected due to alternate remedies. What we are stating is that the state cannot be made party in the instant matter. Your Lordships, it is pertinent to note that there is no evidence that the alleged trolling was state directed or state authorized or even state endorsed. Without state action or state nexus, that is, there is no violation of Article 14, 19, and 21, and the same shall not be invoked. The private online criticism or harsh political speech, even if unpleasant, cannot be directly coordinated to the state, Your Lordships, particularly when it is made up by individuals using this Chirrup Incorporated platform. The users should be made liable for the same and not Chirrup Incorporated as an intermediary itself. Now, Your Lordship, when I am going to post a content in an intermediary platform like Chirrup Incorporated, I should be the person who should be accountable for the same, not the intermediary platform. Once again, Your Lordships, the council would like to draw Your Lordship's attention to the fact that neither the conditions for Vishaga nor the requirements for state liability are met in the present matter. Now, Your Lordship, the Vishaga versus State of Rajasthan clearly mentions that this can be applied only when there is a complete legislative vacuum and a state involvement, whereas here is an extensive digital rights framework which already exists, Your Lordships. It is pertinent to note that we have a cyber crime cell, we have local police stations. Even if that terminology of anti-national was being used in that platform, then what the petitioners, especially Kavya Menon, should have done is that they could have approached the lower courts for civil or criminal defamations. They can even approach the social media grievance platforms, Human Rights Commission, or even the IT Ministry to do the same, Your Lordships. However, they have not exhausted any of these remedies and have approached this honorable court by stating that no, they need direct remedy under Article 32 of the Constitution. Then again, Your Lordship, when this entire question revolves around journalists and lawyers as a whole, the petitioner seeks to address only the issue of Ms. Kavya Menon, Your Lordships. If it was only the issue of Ms. Kavya Menon, they should have invoked a writ jurisdiction, not filed a PIL, Your Lordships, and the same should be taken into due consideration. Now, Your Lordships, has clarified in Kaushal Kishore case, even ministers' personal statements do not bind the state without official authorizations. Therefore, Your Lordships, a few JSP supporters or party workers cannot be treated as state in itself. Now, Your Lordship, the petitioners in their rebuttals have explicitly mentioned the case of Aradhya Bachchan. Your Lordships, in that particular case also, the court has explicitly mentioned about the particular element of actual knowledge, which is reiterated in section 79, subsection 3 of the IT Act, and also subsequently in Rule 3, Subrule 1D of IT Amended Rules 2025. Now, Your Lordships, actual knowledge is something which is to be taken into due consideration. Intermediaries cannot be expected to act upon and take down contents as and when they wish. They should be given either a court notice or any governmental notice to address the same, your lordships, or else they will be called upon under this liability for each and every post made by the users of this platform. And it is a humble request that the same shall not be entertained by this honorable court, that it will indeed lead in a overburdening of cases in the present matter, your lordships. And with that, the council would like to wrap up our surrebuttals. With that, the council rests the case.
The organizer.